You are a civilian. This area is closed to it. You gotta save a couple, but we'll give you a couple. We appreciate you guys, we really do.
Thank you. Hey, can we go this way? Can we walk this way? Hold on. I need a sip.
I'm sure they have a lot of bottles of water. All right, so yeah, they're giving them water, and they're supporting these guys, which I understand the need to protect your property. I'm a Second Amendment enthusiast. I have many, many firearms, and I would protect my property. The question is whether or not Jacob Rittenhouse was protecting his property or his life, or whether he was part of another sort of armed group, armed militia. You can have your feelings about whether that stuff is allowed or not. You can take a position on that one way or the other. I will tell you, if this was happening outside my property, I would be also out on the front lawn with my firearms. But that's not what happened here. This is a different situation. He has been arrested and he has been charged with attempted first-degree murder, actually, because 2 people died. This is the non-traffic ticket complaint and the notice of appear from the Antioch Police Department, and you can see that it sounds like they've already issued a warrant for his arrest. Here is the actual, what we call in Arizona, a Form 4. This is the probable cause statement, and it's going to his residence. It's saying he's defending, he was at one particular location, but they're sending this to his address. It says that he is now a fugitive from justice. In other words, they issued a warrant in the state of Wisconsin, and Kyle Rittenhouse has left the state of Wisconsin. He's gone back to Illinois in order to avoid prosecution. They're saying, since the defendant, after having been charged in Kenosha, the state of Wisconsin, with the offense of first-degree intentional homicide in violation of Wisconsin statute, a copy of such charge, the warrant, is made part of this complaint and therefore filed to the state of Washington or Wisconsin. And in other words, so what they're saying here is that they're charging him, they're issuing a warrant, and they're sending this stuff over to Illinois so that they can extradite him or arrest him and then send him back to Wisconsin. My understanding is that this has already happened. So that is the official document. Now, what I want to do is go over to the Wisconsin statutes. So he's been charged with a crime. It's first-degree intentional homicide, and it's a complicated issue. There's some pretty good statutory law here that we can analyze and decide what does his activity, where does it fit into the statutes. So let's take a look at the first statute, which is the first-degree intentional homicide statute, which comes directly out of the Wisconsin statutes. So here is what it says. It says 940.01, except as provided in subsection 2, which is this subsection down here, whoever causes the death of another person with the intent to kill that person or another is guilty of a Class A felony, which presumably is the highest. Point 2 is about unborn kids, doesn't apply here. However, there is mitigating circumstances. So you can see in this first part of the statute that except as provided in subsection 2, which takes us down to the mitigating circumstances. These are what are called affirmative defenses to prosecution. So the way that an affirmative defense works is if you are charged with a crime, you can say that something did happen. So in this case, if Kyle was arrested for this crime, he can say, and just on the basis of the statute that says, whoever causes the death of another human being with the intent to kill that person is guilty of murder. So he can be arrested and he can say, yes, I did intend to kill that person and I did shoot him. I intended to do both of those things, but this is not murder because X, Y, and Z. And that's where we get into these mitigation circumstances. So here's what they're saying. They're saying the following affirmative defenses, which is what I just explained, under this section are going to mitigate the first degree into a second degree. So it's going to turn it from a 940.01 to a 940.05, which is going to be the second degree. So then we need to look at these other factors. All right, well, what is mitigation? What are we talking about it? The first one is adequate provocation. The death was caused under the influence of adequate provocation as defined in a different section. So that sounds like it might fit because there was a lot of provocation going on here. Both sides were provoking each other. That was kind of the whole point of this. The rioters are protesting. They're burning stuff down because they're angry. The militia or the Wisconsin Strong or whatever they're calling themselves, they're out there to protect the property and fight for their rights and all that stuff. So you can decide which side you want to be on, but they're both provoking each other. Subsection B says, was it unnecessary defensive force? In other words, did the person in this case Kyle, did he believe that he was in imminent danger of death or great bodily harm, and that the force used was necessary to defend the endangered person? This is a big one. This is where a lot of this is going to lie. Death was caused because the actor believed he or she was in imminent danger of death or great bodily harm, and that the force used was necessary to defend the endangered person. That sounds like it fits, right? If you were in Kyle's position, we can't really say clearly about that first shot, but we can talk about the second shot. We can decide whether or not that second shot was necessary or not. If I were in Kyle's shoes, or anybody were in Kyle's shoes, and there's 100 people coming around you, and you're already on the ground, and they're sure, I think you can shoot, because it's very clear that they're coming to do great bodily harm or cause your death, and that's directly from the statute. So that's subsection B. So I think as to the second video, that's going to be pretty clear. They're going to be able to show that, but the real question is going to become whether or not it applied to that first shooting. If it didn't apply to the first shooting, then he's not going to be able probably to carry that over into the second shooting. The other ones, prevention of a felony. Death was caused by the actor believed that the force used was necessary in the exercise of privilege to prevent or terminate the commission of a felony. And that is something that is also fits, right? I mean, if the rioters are burning down buildings and they're destroying property, those are all felony things. You can't just burn down a furniture store. It's not allowed. So if he's preventing a felony and he believed that this force was necessary and he was entitled to use it, then that subsection would apply. And the final bullet point is about coercion, and I don't think that applies at all. So then the question becomes, what about the adequate provocation? So we just saw that right here, right? The adequate provocation. Death was caused under the influence of adequate provocation as defined by 939.44. Here's what we've got in that subsection. Adequate provocation. It defines both of those right here. It means sufficient to cause complete lack of self-control. And provocation means something that the defendant reasonably believes the intended victim has done, which causes the defendant to lack self-control completely at the time of causing death. And that doesn't fit. Adequate provocation is an affirmative defense to first-degree intentional murder and mitigates the offense to second-degree intentional murder, which means it's going to drop it down a level. But is this provocation? It doesn't look like it to me. The defendant reasonably believes that the intended victim has done, which provides the defendant to lack self-control completely at the time of causing death. So this would be more like a situation that Kyle lost control of something. He really couldn't control himself. Normally he's in control. Now he's out of control because he was provoked by the other persons or the other persons. And it just doesn't seem like it fits to me, at least from the first video, but we really don't know. There's a lot more that I think needs to come out on that first video. But let's say that this is something that he was able to show that one of those affirmative defenses applies. We're going deep into the weeds on some of this law stuff because I do think it's important.